The case itself is the Richard Heller case. Richard Heller is a reserve police officer in Washington, D.C. And he wanted to be able to have a gun, a weapon at home for his self-protection. The District of Columbia passed ordinances that prohibited the carrying of a weapon, an unregistered weapon. So you had to be able to get it registered, and then there were other conditions around how you would be able to retain a weapon. They made it a crime to carry an unregistered weapon, and they prohibited the registration of handguns. But they permitted the police chief to be able to give you a permit for 1 year and a license for 1 year to have a weapon. However, even if you were able to get that license from the police chief, you then had to store the weapon under lock. And secondly, you had to dismantle the weapon. What that meant is if you had it for self-defense and you were under attack, you would have to unlock the weapon, then you would have to assemble it, put it back together so you could use it. And so Heller filed a complaint, a lawsuit, to say that this is denying him his rights to have a weapon. This case was brought in the District of Columbia because the District of Columbia depends upon the federal court system to resolve its disputes. And so it automatically gets into the federal court system. The lower court rules in favor of the District of Columbia. It then gets appealed, and it gets overturned. Then the city appeals that, and it eventually winds up in the Supreme Court. And so this is where Justice Scalia gets to write the decision in a 5-4 majority. And what he holds in his decision is the Second Amendment protects an individual right to possess a firearm unconnected with service in a militia, and to use that arm for traditionally lawful purposes. He goes on to say that the opening clause of the amendment does not limit or expand the scope of the second part, the operative clause. Well, I mean, the word is in there, the militia is in there for some reason, but Scalia kind of dances around it at this. And he says that the prefatory clause, the opening clause, the militia comprised of all males. So he's saying here that we mentioned the militia, who's in the militia? Well, all males between like 16 and 85 are, members of the militia. And so he's saying, so it's everybody. Well, it's not everybody. It is those who are specified. But, and then he goes on to say that the Anti-Federalists had feared that the federal government would disarm the people in order to disable the citizens' militia. And again, there is nothing in the Second Amendment that says anything about a citizens' militia. There's nothing in the Constitution that says anything about a citizens' militia, but Scalia skillfully weaves it in to his decision. Mind you, you're welcome to say, but wait a minute. So if anybody has anything that they want to interject, you're welcome to do that. And you know, he goes into the detail of the case. Mind you, this, as we heard from Amy Comey Barrett, the court is to decide the case before it and not to expand beyond that. So you could easily have said that the requirement for locking the weapon and for dismantling the weapon was unreasonable, and you could make a narrow decision that would then allow Heller to have his weapon, but no, it's broadened out to everyone has a right to a weapon. It is held that the Second Amendment protects an individual right to possess firearms, and that the city's total ban on handguns, as well as its requirements that firearms in the home be kept non-functional, even when necessary for self-defense, violated the right. And again, you could have said that just staying within the ordinance of the District of Columbia, that the rules for licensing were overly restrictive and didn't make sense. And so you could have kicked it back down to say, reword that, or however you want to do it. But now it's being broadened into a bigger decision, bigger case. Yeah. And in interpreting the text, we are guided by the principle that the Constitution, written to be understood by common everyday people who frequently reference the prefatory clause, not factory clause. And the dissenting petitioners and today's dissenting justices, the dissent, believe that it protects only the right to possess and carry a firearm in connection with militia service. Respondent argues that it protects an individual right to a firearm unconnected with the militia. And, you know, he goes on to talk about the right of the people, and that can't be constricted to keep and bear arms. He goes into, you know, length about what bear arms actually means. And so as he goes through it, my comment to it is that Scalia repeats all the words related to militia, but they somehow are irrelevant to him. The words become invisible to Scalia, just as native peoples became invisible to him. He goes into case law and what was decided, that the militia comprised all males, and he gives the Webster definition: the militia of a country are the able-bodied men organized into companies, regiments, and brigades, and required by law to attend military exercises, but at other times left to pursue their usual occupations. So the militia is how we commonly refer to the National Guard. It's a state agency. It's not a group of yahoos who simply decide to get several cases of beer, drink, shoot guns, and say we're a militia. No. And so he says, petition, you know, take a narrower view of the militia, stating that militias are the state and congressionally regulated military forces described in the Militia Clause. That's right. That's what's described in the Militia Clause. Right. Yeah. Although we agree with the petitioner interpreted that the militia means the same thing in Article 1 and the Second Amendment, yeah, we agree. We believe that petitioners identify the wrong thing, namely the organized militia. Are you following his logic here? He agrees with the argument.
No.
He's agreeing with the argument that what you're reading in the Constitution, in the assorted articles and the amendment are the same thing, but they're not the same thing. Oh, God. And so, as I say, I have no idea what his point may be. The Constitution gives Congress the power to tax for funding a militia and other tasks such as training. Subsequent legislation required all males between selected ages to be part of the militia. The Second Amendment says those in the militia have a right to be armed. Scalia broadens the scope to say everyone has a right to be armed.
So, okay, Sal.
Yes,
It
go
drives
ahead.
me so crazy. But I don't know even what to say, except that these people that believe in originalism, and yet whenever it suits them, they just turn it on its head. So now suddenly everybody can. It says something different in the Constitution, and yet they just cherry pick what they want and then ignore everything else. And this whole thing about originalism to me makes no sense, because the founders, the people who wrote the Constitution, could not imagine AR-15s and mass shootings in schools. They couldn't even imagine these things. And it's crazy not to take any of that into account. I just don't, it's not logical.
But here's the thing, man. Even if they did consider that, they're saying, the people writing the Constitution, is that we're not dealing with that. That's for the states to decide.
Oh, God.
We are talking about the militia. We're only talking about the militia.
Right.
And let me just, hopefully I can get to that quickly. Let me find where here. This is from the book titled Madison's Notes. I think it's Madison's Hand. They're revising the Constitutional Convention. Mind you, during the Constitutional Convention, there were several people who were taking notes. Madison was one of them. And Madison, his notes were kept forever. He made changes to them later on in his life as time went on and he saw different things happening. He would add to it.
Welcome to Zoom. Enter your meeting.
That was Justice Scalia.
Enter your participant ID followed by pound. Otherwise, just press pound to continue. Please enter the meeting password followed by pound.
Someone's trying to get on by phone, I believe.
Maybe it's hackers.
You have not entered any numbers. Please re-enter the meeting password followed by pound.
Okay, so mind you, the Library of Congress classifies the manuscript as a top treasure among the written documents it holds in trust for the American people. And so the notes by Madison are really considered like the Federalist Papers. They're serious things. And so if I go into it, and that's one, source. You can go in there and you can word search militia. Let me just do that.
Well, while you're doing that, let's remember that Warren Burger, who was a conservative justice appointed by Richard Nixon, said that he believed the sale, purchase, and use of guns should be regulated similar to how automobiles and boats are regulated, and that if he were writing the Bill of Rights today, he would remove the Second Amendment. And
Yeah,
that was like 30 years ago? I don't know, a long time ago.
well, that's probably about 40 years ago. Yeah, that he said that. But here is, again, if you go and you search through Madison's notes, the whole discussion about Second Amendment and also the militia is all about we want to protect, we want to have a militia that can be armed. The concerns were all about a militia that wasn't armed and who's going to pay for the weapons and all of that. But it's nothing about an individual right. It's not an issue for them. And if I go into the, let's see, Second Amendment power, the Arms Convention, little nerdy, but when you get into the writing of the Constitution, they broke down into different committees. They had multiple committees taking on different issues so that they could try to get to some point where they could start to have a document. Mind you, they were meeting in Philadelphia and they thought it was going to be over with in a couple of weeks. And it's gone on for months through the summer in Philadelphia at a time when they don't have sewerage or anything like it. It was a horrible place, horrible. Okay. But they kept these notes. And so when they're talking about the militia, these are the notes from the militia. And and so what the report of the Committee of 11, they analyze this thing, they make a report, and now it's for people to start to refine it and get it into some wording. Mind you, they continued debating and arguing all along until finally Governor Morris gets fed up with it. And he said, and he then picks out several people and he says, you come with me, we're going to go write the Constitution. And that's how the Constitution was written. But it was taken from all of these notes and all of these debates. And so under consideration to make laws for organizing, arming, disciplining the militia, and for governing such part of them as may be employed in the service of the U.S., reserving to the states, respectively, the appointment of officers, authority of training the militia according to the discipline prescribed. So as you go in, you see, this one says, I don't think you need to have authority and training in there. We can get that out. Another one says, no, I think we ought to keep it. You know, that's the debate. But as you go through the whole thing, you will not find, let me see if I can, not only do I not find citizens' militia in the Constitution or in the Second Amendment, in the notes from the debate at the Constitutional Convention, there's no discussion of a citizens' militia. So where the hell does Scalia come up with a citizens' militia? It is the linchpin of his decision. If you don't let everybody have a weapon, you're saying we can't have a citizens' militia. And we got to have a citizens' militia to fight back against a tyrannical government. Okay. That's as nerdy as I'll try to get here. Now, I will, you know, at any point, if you want to discuss more of that or want me to highlight more things, be happy to do it. I want to share with you someone else discussing the Second Amendment, so that it's not just my talking about it. Okay, here we go.
You want to get the Second Amendment?
Again. As with basically,
Oh my God.
has to do with laws for rights in this country, it all comes down to language. So let's take a look at the Second Amendment. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. If we set aside the moral issue and just focus on the legal question of whether or not we have a personal right to own a gun, there's really two main things that people disagree on. One, was this first part, commonly called the Militia Clause, designed to limit gun ownership only to people who are actively serving in the militia, which today would be the National Guard? And two, what does keep and bear arms actually mean? Or more specifically, what did it mean in 1791 when the amendment was written? Because that second question has gotten a lot more heated in the last year or so, if you can believe it, because of this weird sounding field of research called corpus linguistics, which we'll get into in a bit. Anyway, while today we might think the Second Amendment protects our personal right to own a gun, a lot of experts would tell you that wasn't the case for most of US history. For basically 200 years, the Second Amendment was commonly understood to link gun ownership to militia service. And that understanding wasn't even really challenged at the Supreme Court until the eve of World War II. In 1939, two bank robbers in my home state of Arkansas tried to claim they had a Second Amendment right to own a sawed-off shotgun. A unanimous Supreme Court said, nice try. There's no way you can link sawed-off shotgun to militia service. So the government can make that particular gun illegal if it wants to. So almost 150 years after the Second Amendment was ratified, this ruling kind of confirmed the common understanding of it. The government didn't have to regulate or prohibit firearm ownership, but it could if it wanted to, because the right was pretty well understood to be tied to some sort of militia service. And this interpretation held for another 50 years or so.
There was no mention of personal self-defense at all in the Constitution, in the Second Amendment. It was basically understood to mean the carrying arms in the context of some kind of military service.
So how did we go from a common understanding of the Second Amendment gun ownership to militia to where we are today? Because the Supreme Court case that actually changed all of this didn't even happen until 2008. But by the time we got there, most Americans already thought the right was personal, not militia-based. And for that, you can mostly thank the NRA. From the late 1960s to today, the NRA went on the offensive in acts and speeches and TV appearances, pushing the narrative that you have a Second Amendment right to own a gun, and the government's trying to take it away from you.
Their goal is to eliminate the Second Amendment and our firearms freedoms so they can eradicate all individual freedoms.
All right, so our timeline is all over the place by this point. We have the Constitution, a Supreme Court case in 1939, the NRA from the 60s to today, another court case in 2008. Yet somehow I can't even explain how we ended up with a personal right to own guns without going back to 2003. Because that's when these guys decided it was time to take on the Militia Clause and prove once and for all that it did not limit your personal right to own a gun.
The three of us litigated the Heller versus District Columbia case.
The three being Clark Neely, Alan Gura, and Bob Levy. Bob is the chairman of the most influential libertarian think tank in the country. The fourth guy in that photo is Dick Heller. He was their model case. Heller was a special police officer in Washington, D.C., which meant that he carried a gun for work. But he also wanted to own a handgun at home for what he said was self-defense. But because D.C. had a law on the books that banned all handguns, he wasn't allowed to have one.
D.C. was a particular right place to litigate Second Amendment because they had the most draconian gun control regime in the country. And yet they had the highest rate of gun violence in the country.
So, thanks to Bob and his colleagues, the Heller case winds its way to the Supreme Court, and we end up with the first definitive ruling on whether or not we have a personal right to own a gun. The court started with the Militia Clause.
The Militia Clause was a prefatory clause to give one of the main reasons to recognize the right to keep and bear arms.
Stephen Holbrook wrote a hugely influential opinion for a bunch of senators and congressmen in the Heller case. He's saying that the militia clause announces one important reason for why people should be allowed to own guns, but it's not the only reason why.
Invariably, if you refer to the right to bear arms at the time of the founding, it refers to an individual right.
That was a pretty big departure from earlier decisions. But that's what Justice Scalia said in his 5-4 majority opinion. After Scalia addressed the militia clause, he took on disagreement number 2. What does keep and bear arms really mean?
We conclude that it means pretty much what it means today, to have and carry weapons.
Scalia got that particular part wrong. That he just blew it in terms of the meaning of bear arms.
Dennis Barron is a leader in the field of corpus linguistics, which I mentioned earlier. All it means is that scholars and researchers gather up tons of sources. I'm talking like every single piece of text written in a given time period. Then they analyze how exactly a term was used and understood in that time period. Now, this becomes important because Scalia was an originalist. He said the court can only interpret what the Constitution literally says, and only how voters would have understood that language at the time that it was written.
We argued that bear arms always has a military context. As the historian Gary Wills said, one doesn't bear arms against a rabbit. But in 2008, the Supreme Court said no, bear arms simply means tote a gun. And they're wrong.
Professor Barron's analysis didn't sway the court in 2008, but he says the evidence is actually even more compelling now, because in the last few years, more comprehensive source collections and more powerful computer tools have supercharged his field.
I came up with about 900 individual unique uses of bear arms. And of those 900, I found 7 that had nothing to do with a military sense, although 6 of them were ambiguous.
That's the argument.
Okay, so what I wanted to highlight there, let me get to this next one, is that the Cato Institute has initiated this thing to make the Second Amendment mean something other than what the Second Amendment means. Where did the Cato Institute come from? Founded by Charles Koch.
Yep.
Part of the whole apparatus that was to try to dismantle the American government, to give an intellectual validation of ideas that were considered bonkers. And so because if you went out into the intellectual world, you were going to find that they were not going to, the academic world, historians, others like that, they were not going to buy your stuff. And so here is Jack Raycove. He is a professor of history, of law at Stanford University, and he appears on a show with Lawrence O'Donnell to talk about the Second Amendment and history.
It has turned out that way, that they are. But when you watch the Supreme Court justices and their clerks, in effect, playing the role of amateur historian, staring at these words, believing that if they stare long enough, they can know what was in the mind of the people who wrote them. What is your reaction as a historian?
Well, since Andrew Weissman was talking earlier about the whole Second Amendment issue, basically it's turned into a real mess. And there's a lot of discussion going on among historians, among lawyers who read history, among jurists, particularly in the aftermath of the famous Second Amendment decision in the Bruen case from a year and a half ago. The court says, on the one hand, it wants jurisprudence to be deferential to and respectful of history and tradition as well as text. On the other hand, its method for dealing with history, most historians like myself would argue, has been very inadequate and very flawed, and in some ways really irresponsible. And in some ways, the Second Amendment because it's been so much litigated, is the best example of this. I mean, the fiction, the theory underlying the original DC versus Eller case in 2008, that the Second Amendment was really about a personal right of self-defense. To a historian like myself, that's complete and utter nonsense. Nobody in the 18th century thought, when the Second Amendment was being debated, that they were discussing personal right of self-defense. It was all about the militia. And since I was the lead author of the historian's brief to DC versus Eller, I have very strong feelings on the subject. But the court has kind of laid down this challenge, and now it's trying to make sense about a deal with it. And judges around the country are actually begging for help because they realize there's a limit to their historical intelligence, and the whole question of how should judges at every level of jurisprudence, how should they be better informed historically, become a real challenge, a real problem. And I don't think we've figured out quite yet what the solution is.
Well, one possibility is don't take all of your clerks from law school. Takes to have at least one of them be a historian, because Supreme Court's justices can have 3 or 4 clerks if they want them. They could easily have one be a historian.
Right. Well, look, I've had about 7 or 8 of my Stanford students, I'm proud to say, have coached on the Supreme Court. I'm Stanford history majors, so I think that's a nice fact. Whether it's adequate, given the way the appointments process works, is another question. One way to think about this is maybe historians, maybe one should think about history as a form of expertise, and the courts, the Third Judicial Center, should think about ways of constituting panels of historians. I'm involved with a group of historians and legal types at NYU, at the Brennan Center at New York University Law School, and we're actively working on this problem. In fact, we're about to make an announcement of our very existence. So I think there's a real challenge out there as to how to make the courts in general, be better informed about how to work with historical materials. There's a lot of criticism of what we call law office history, which takes the form of find me a site which will sustain the argument, the conclusion.
Can you understand him?
There has to be a better way to do it.
Okay.
And I have one more I want to show you here. And from this kind of manipulation, we here is what we arrive at.
That image was quite controversial to a lot of people. Some people saw it as irresponsible, some people saw it as dangerous, threatening, whereas other people, including you, saw it as a symbol of something very different. What was it to you?
Powerful. Protecting. That's my freedom.
But the people who criticize you, what do they see?
A right-wing lunatic.
18 years ago, I travelled across the United States, exploring America's deadly love affair with a gun. I witnessed the grim results of these weapons in hospital emergency rooms, morgues, and the confused aftermaths of mass shooting sprees. After each new massacre, the newspaper headlines were always the same. Why did it happen here? Since my book was published in the year 2000, more than 500,000 Americans have been killed by firearms in the USA. 527,000 people dead and many more injured. I decided to return to the subject, to track down each gun owner who I'd met and photographed those years ago, to understand why, despite this death toll, there is such fierce resistance to even moderate gun control laws in the USA.
His finger wasn't even on the trigger. That's not what the picture is about. He's not trying to harm me. He's trying to protect me.
I'm looking out for myself, my family, my neighbors.
Yeah. One.
Who was that guy, Sal? That British guy?
Well, we're going to hear more from him next week. I wanted to see if I could let me get this up that I wanted to show you. But I wanted that's we're going to go into next week as to why were they doing this? Why did they want to make this a controversial issue? What was their overall objective? And so we're going to talk about that next week. And I wanted you to, we're going to see what has emerged out of this irresponsible legal effort and historical manipulation. What has been the consequence of that? And why did they do it? Mind you, this today from Axios Atlanta, bill would create sales tax holiday for guns. The Georgia Senate Republicans advanced a bill yesterday that would create a sales tax holiday for guns and ammunition. Okay, with that, open for discussion. And I know we've been open for discussion throughout, but
well, and I heard that passed too, the sales tax.
Yeah.
Well, it passed the Senate. I don't know if it's gone to the House.
Right. It has passed the Senate. That's right. Yeah.
I wonder if they have that bill in any other states besides Georgia.
I don't know. Yeah, but this frenzy of I've got to have weapons to protect myself and my family and my property. This is a theme that has been foisted upon people, and it was developed while we had the civil rights movement going on, and we had cities that were on fire, and people were terribly afraid of Black people starting a civil war. And that was the idea, was that they're scared, let's agitate them for weapons. And the Second Amendment became a tool for being able to agitate them.
Wow. I'll just make a comment. I thought that Scalia had an outcome he wanted and then just went searching for anything that would support it.
Well, that's right. And that's what corpus linguistics is about. It is, remember, Scalia is an emissary of the oligarchs who are wanting to separate Americans from America. One of their tools has been the Second Amendment. They have other tools that they're also doing, and the court has become a very important component of that strategy. As I mentioned last week and the week before, the American Bar Association that used to vet judges has about 1.5 million members. The Federalist Society, created by the oligarchs, has about 65,000. It was created so that there would be something that would oppose what the American Bar Association is doing. They wanted someone else to vet judges that would have a patina of credibility. And so they created the Federalist Society. Today, 6 of the 9 justices are members of the Federalist Society. And it's important to understand, this is a thing that's been worked on for a long time. As I said, I'm going to send out a piece from Timothy Snyder, professor from Yale, and he talks about how what's going on now didn't just happen now. It's not about Donald Trump. It's about the movement conservatives who have been strategizing, funding, and creating an apparatus to dismantle the American government. And that's a difficult thing to accept. But mind you, right now, when the issue came up about does the president have immunity from prosecution, and the 11th Circuit said, of course he didn't have immunity. Are you saying that the president could order SEAL Team 6 to go out and kill someone and could get away with it? And it was a great line, and you thought, well, of course not. Today he can. I mean, because right now he can order people to go and kill his political enemy or anybody. And he also has the pardon power. So I tell you, go kill this person for me. You go do it. You get arrested. I pardon you. I mean, we no longer have rule of law. You can't, the whole system. I mean, you go into that Constitutional Convention, it was about balance of power. They did not want to have another king that would have the power to simply say, take him out to the guillotine. And if you read through any of the stuff, there's the work by Pauline Myers about the Constitution and ratification and the whole debates that are going on. Their view was the power was going to be with the legislature. The executive, the idea is the legislature passes law, provides the funding for the implementation and the administration of the law. The executive does the administration and implementation of the law. And it does it by way of the agencies it creates to do that we now, Elon Musk doesn't understand. That is the bureaucracy. That means administer and implement.
What about, oh, sorry.
No, go ahead.
Go ahead and unmute yourself again. Not using the raise the hand. We have
okay. What about the argument that murder is a state law and it would be, okay, the rest of the question.
Yeah, sure.
Then you could kill him in DC because it's under federal jurisdiction. I'm sorry, but that's the truth.
Well, look, it is. When you have that amount of power and you pull together all the legal minds to be able to skirt around whatever remaining obstacles might be there, forget, you're done. All those protections are gone.
Well, some people keep saying, oh, these court cases are going to save us, but they're already saying that they don't have to abide by court decisions.
Look, so
I mean, the legislature is doing nothing. Congress is doing, they're doing nothing to stop it. And if they ignore the courts, which they say they're going to do, and people just don't listen to them, they've said pretty much all of this, and people don't listen and say, oh, well, Trump just says this stuff. He wouldn't really do it. Well, did you see that Elon Musk press conference where Trump was sitting at his desk? Elon Musk is running everything now, and the man is wacko.
And I think he does understand the the ramifications of what he's doing. He's a smart guy, and he's not confused by the bureaucracy. And if he tears down the bureaucracy, how the whole deck of cards comes down.
I can't find the raise the hand on my computer.
Go ahead.
But RFK just got confirmed. Do you think within the 4 years, how long it will take before people are in the streets? Because harm will surely come.
Well, here's the scenario that I speculate is that people will get out on the streets. The police will be dispatched. Before the police are dispatched, I'm sorry, the vigilantes will be dispatched to engage in violence. They will then say that that demonstration against, whatever crazy thing has come out of the Trump government, they will say that those protesters are violent. They will have been instigated by the vigilantes, but they'll be violence. Then you have the predicate for the Insurrection Act. And what you then do is you suspend the Constitution. And then there is no election in 4 years. There are no elections in 2 years. That's done. They are marching towards the what we think we have as a system is being totally eviscerated. And so to your point, Madeline, as to the courts have said, you can't hold back that funding. Okay, so they continue holding back that funding. And the court then orders the U.S. Marshals to go and force Treasury to do that. Who controls the U.S. Marshals? The Department of Justice.
Executive branch. Well,
Executive
Department
branch.
of Justice, but now.
But so you have eliminated that as a force that can do anything. So you ignore the court. And if you get to the point of the Insurrection Act, you can lock the door to the Supreme Court. You can lock the door to the legislature. And they will then have an autocracy in power.
Nancy, would you go ahead?
Yes, I heard that Donald Trump in the Oval Office said that he had to follow the judge's orders. My reaction to that was, okay, you follow it up to the Supreme Court rules in my favor, and everything's fine. Or if they don't, then we'll rethink doing what the judges said. My hope was that would take 2 years and we'd have an election before then. What is wrong with that idea?
Well, you can quickly unravel everything where there will not be elections in 2 years. It's not unfeasible to do that. You can, I know Trump said, oh, well, he's asked, will you follow the court's order? Well, of course I'll obey the courts. I'll appeal, but, of course but understand, Trump has said loads of things that doesn't mean anything. It has no credibility.
He said he had nothing to do with Project 2025.
Right. But again, I want to keep emphasizing, it's not Trump. It's the people who are behind it. When Trump won the election in 2016, the Koch brothers were supporting Ted Cruz at that time. They did not think Trump would win, but Trump won, and Trump didn't think he was going to win. And so when it came, now he has to form a government. He was lost. Koch stepped into that void. And if you look at the people that he appointed, the Scott Pruitts and people like that, they came from Rex Tillerson, a fellow oil person. So the Kochs were then kind of populating the administration with people that they were recommending. But they didn't have their full strategy. They didn't think that opportunity was going to happen then. This second time around, they were prepared. Project 2025. These are the products of the Heritage Foundation and the Federalist Society and their other institutes. Cato, Manhattan. So the plan now is a much more sophisticated one, and I would argue that the loyalties of the people who are being promoted, the Kash Patels and the others, is not to Donald Trump. It'll be to the oligarchs. Yeah.
Aileen?
Yes, so I heard Trump say at one of his outings there that vote for me, this will be your last election. I mean, he told us no more elections. And also, I don't think too much of legislature anymore, because I mean, they're spineless wonders, or I call them really worse things than that, but you'd be ashamed of me if you heard it. That's all I have to say.
I would not be ashamed of you, no matter what you said.
Oh, thank you, dear.
But it's important to understand the strategy that they put together post-World War II that's continued down its path. They've had their Venn diagrams of who they have to get in what first, followed by what came next. And they've adjusted it over time. When the selection of candidates came out of the hands of the party bosses and went to primary elections, really a product of George McGovern in when he ran against Nixon. What they saw was the opportunity to control who was going to be a candidate. And this idea has morphed over time, really coming to maturity with the Tea Party. And that is to say, if you are a congressperson and you are not doing what we want you to do, we will flood your next primary. We'll flood it with money that you will not be able to compete against. And so they've gotten into position those who will sell their soul to the devil and be that candidate, get elected, and those who haven't gone through that bloodletting, exercise of saying I'm loyal to you. They are afraid that if they don't do what the oligarchs want, then they will lose their seat in the next election. So it's another part of that strategy that they've put together, which is to, again, the overall goal, separate Americans from America so we can take over the government, dismantle it, and then we run the show.
And we'll all be serfs again.
Yes.
And that's the good news.
Well, as Tim Snyder says, and again, I'll send that out with the summary, class summary. He says they will not know how to govern, and it will fall apart. But they, you know, it's just a matter of time to how long it takes before everything collapses. But they won't be able to govern.
Yeah, the good news is that, the price of eggs is still high. He's not lowered that. The inflation rate was up, in most recent. So yeah, nobody's governing.
Well, and we started the walk away from NATO today when Pete Hegseth went there. Between cocktail hours, he went in to say, if you're going to help Ukraine, that's a European deal, not ours. And look, Putin. I think one of the questions for Putin is, can he keep his thumb over the oligarchs? Does he have enough power over the oligarchs? And what would be in the oligarchs' interest to get rid of Putin? So, there's that fight going on, and Ukraine could have been the thing that broke his back, as we saw there was an effort at a coup. But now the tide is now turned in Ukraine because America's walking away.
Yeah, every point that the Russians wanted has been agreed to already. It's like, ooh.
Sal, would you say that we are living through the fall of the Roman Empire?
The book that is the book about the Roman Empire is it's not the rise and fall, it's the fall of the Roman Empire. It's the title of the book. And it says from the very beginning it was going to fall. Certainly there's differences, but I think we're more, I'm just giving you my opinion. I really think we're 1933 Germany right now.
I agree. Yeah.
Yeah,
that was going to be my comment. Welcome to 1930s Germany.
Yeah. And the thing is how many people from Germany, if you ask them, how did we get here? What happened? They would say, I don't know. We're sleepwalking through it and, reacting to events and being manipulated, and the propaganda was very effective. But once Hitler had his hands on the controls, it's the people that he surrounded himself with, that once they had their hands on the controls, there was no turning back. There was nothing gonna reverse it, except for defeat in war. And believe me, I hope that I am dreadfully wrong and incorrect. I hope that you invite me back here after several years just to tell me how incorrect I was and how we're doing fine as a nation. And you were wrong, DePasquale. But I will be surprised if we have mid-year elections.
Well, I definitely hope you're wrong there too, but it is afternoon. So you want to talk about what you're going to talk about next week?
Well, I want to get into the why. Why did they pick the weapons as
2 weeks? 2 weeks, yeah.
In 2 weeks, that's correct. Why did they pick weapons as a tool to drive wedges? It was one of many issues, abortion and others. But why did they select weapons? And I want to talk about that. The political climate was conducive to it. People were frightened. They saw the opportunity, they exploited it. Okay, everyone.
Well, I don't know if we should give you a round of applause or
Yeah,
not, but it's good
What, no.
information.
One big sigh.
A collective sigh. That's good. All right. Bye-bye.
Thank you.
Okay,
Thank
everyone.
you.
be
Bye
safe.
all.